My Lord, Honorable Justice Isaac Lanaola, Supreme Court of Kenya Justice, President of the East African Law Society, Mr. Bernardo Undo, Moderator for the day, Mr. Enoch Barata, colleague advocates, good afternoon. Welcome to this East African Law Society webinar that seeks to tackle a very important emerging area on the use of social media and the dependence of the judiciary. We have today organized a great panel to discuss this key important topic. For you, social media as an advocate. I'm not the speaker for the day. I'm going to welcome the moderator of the day, who will then introduce the president of East Africa Law Society, who will then welcome our main keynote speaker. Thank you. Welcome, Enoch.
Thank you very much, David. It is a pleasure to be here for this webinar. I am pleased to be the moderator for this webinar and the topic for today. As you have indeed stated, we have the Honorable Justice Mr. Isaac Lanaola. I will ask perhaps the president of the ELS to set us moving with an introduction, and then we can start from there. Thank you very much.
Thank you so much, Enoch. And thank you, David, also. Let me take the opportunity, first of all, to introduce our moderator for this afternoon, Mr. Enoch Barata, who is a senior partner at Birungi Barata Associates and is the head of the firm's banking, corporate, and commercial and litigation department. He is an advocate of the courts of judicature and received specialized training in finance and financial law from the Center for Finance and Management Studies at the University of London. He is a member of the Uganda Law Society, the East African Law Society, the International Bar Association, Tax Planet, and the Institute of Corporate Governance of Uganda. Enoch, you're very welcome to moderate this session. Let me take the next opportunity to welcome Honorable Justice Isaac Lanaola. His CV, as you can imagine, is long and detailed. I'll therefore just try to be able to summarize it. Honorable Justice Isaac Lanaola is a Justice of the Supreme Court of Kenya. He joined the Judicial Service in 2003 and first worked as a resident judge in Embu, Meru, Machakos, and Kakamega High Courts. As a High Court judge, Honorable Lanaola also served as a commissioner at the Judicial Service Commission, where he also served as chairman, stroke Human Resource and Administration Committee. He was previously a member of the board, Judicial Training Institute, and chairman and member of various judiciary committees, as well as chairman of the Kenya Magistrates and Judges Association. He has also served as judge and deputy principal judge of the Court of First Instance at the East African Court of Justice from 2011 to 2018, and also as a judge at the Residual Special Court for Sierra Leone from 2013 to date. Justice Lanaola has also received several awards, key among them being awarded by the Law Society of Kenya for distinguished service in the administration of justice in 2008, the East African Law Society Honorary Membership Award for exemplary service, and the development of jurisprudence in Kenya in the East African region 2015, as well as distinguished service awards in the service of the International Association of Refugee and Migration Judges 2014. He is also a recipient of the Moran of the Burning Spear from the President of the Republic of Kenya for distinguished service in the administration of justice in Kenya and the East African region. He has also been named Jurist of the Year by the International Commission of Jurists, Kenya Chapter 2019. So Honorable Justice Isaac Lanaola, please allow me welcome you to the East Africa Law Society. On behalf of the Governing Council of the East Africa Law Society, may I take the opportunity to appreciate you for the support you have continued to give the East Africa Law Society. I know that this topic is very important, and it's a topic that is being discussed not only in Kenya, but in Uganda and Tanzania. So we would like to hear your thoughts on this important topic. Thank you, and thank you so much.
Thank you very much, President, and thank you again for the invitation and for your continued partnership with me and the Kenya Judiciary. I keep telling my friends that I miss my days at the ESCJ, because the ESCJ, my time there was wonderful because of a lot of the cases that you guys brought to the court. And I enjoyed the submissions by the likes of Professor Sempebwa, Mwamu, Onsongo, and the others. So thank you for the good work you keep doing. And I'm happy that you chose me to debate on this very, very important subject. Let me begin by saying that social media, or what is generally called digital media, is a new, yet not so new phenomenon in our realm. Because a lot of the younger lawyers and younger judges know about Facebook, LinkedIn, Twitter, Instagram, MySpace, and YouTube. And some of you here are also bloggers. And I ask myself the question sometimes whether, in fact, it is right to call social media just another kind of media, because I hear people saying that the print media is the mainstream media. But I'm starting to believe that, in fact, social media is the mainstream media. Just yesterday at a meeting I'm attending where I am right now out of Nairobi, we had a conversation around the same question, and we discovered that the Daily Nation, for example, in Kenya, has a daily circulation of 170,000 copies. A tweet by our Chief Justice a few days ago attracted 304,000 people in a very short period. So that in a few seconds, the tweet had more audience than the Daily Nation in a full day. So perhaps it's a misnomer to call social media not the mainstream media. Let me jump in straight into social media and judges. Whereas a lot of the younger lawyers, for example, and younger people in our countries are in social media, judges have taken time, at least in my jurisdiction, to engage with social media. And the fact that information circulated in social media has a very wide audience, a very short time, has now attracted our attention because the damage it can cause to a judge or judiciary is immense. And what a judge may say in social media may be misinterpreted very quickly or blown out of proportion, or in fact read in a very different context from what the judge intended, and doubts then are raised as the propriety of the affected judge. In Kenya, very few judges are on Twitter, so far as I know, and I probably would know. A few are on Facebook. I don't know any on Instagram. And even those on social media, on Facebook, for example, and I counted about 5 this morning, only about 3 are really active. The others are very happy to follow. But that's not enough, because there are challenges with the judges being on social media. So the question that I keep asking myself, being on Facebook myself, are the following. Should a judge maintain an online social networking presence, and how far should he or she go? Should there be a limitation on the persons with whom the judge can connect with? What information can a judge share or not share? Should a judge, as part of full disclosure, disclose their social media connections? Yet judges are human beings. They have a social life. They have a presence. They have friends. They have family. They have relatives. They have classmates. They are people they care for. The new world is attractive to anyone, including judges. Should a judge therefore recuse himself on account of perception that your social media friends are much closer to you than they should be? Yet social media is an important tool today for publicizing information. And knowledge comes from, I know this for myself. I learn a lot from Facebook. Sometimes I get information from Facebook that I cannot get on social media, in the print media, or from TV, and I don't watch TV much. So that in due course, there's no doubt in my mind, social media must become a part of the judicial function. To what extent then should a judge participate in social media? From my readings and experience, there are very many, and there are divided opinions as to this, the effect of a judge maintaining social media presence. For example, let's begin from Facebook. Facebook has the friends, you receive solicitations to be friends. Some of us would accept friends en masse. And you have this whole lot, I think I'm now at 3,000 friends on social media, on Facebook. Some of these people I don't know myself. So the question is, how far should you go in your relationships in social media? So on Facebook, for example, is a friend on Facebook a real friend in the common parlance of friendship? This question confronted the Supreme Court of Kentucky in the case of Slash versus Kentucky. And the judges there said that friendships on Facebook and other similar networking sites do not necessarily carry the same weight as true friendships or relationships in the community. The degree of relationship between Facebook friends varies greatly, from passing acquaintanceships and relatives to close friends and family. The mere status of being a friend on Facebook does not reflect this nuance and fails to reveal where in the spectrum of acquaintanceship the relationship actually falls. Facebook allows only one binary choice between two individuals where they either are friends or are not friends with no status in between. So suddenly, friendship in Facebook has taken a different context from what we know in common parlance. Yet again, the Kentucky situation is not commonly accepted. And others have argued that when a judge, for example, sends or accepts a friend request from or to an advocate, you are specifically targeting that person as a special category of people and rejecting others. And therefore, the presumption is your friends on Facebook have a preference and you communicate with them differently from other people outside your friendship in social media. It has also been said that if you therefore accept a friend's request from an advocate, that person is one of the chosen few in your circles, including in your judicial work. So that question is not settled. And when we go, for example, when we make our declarations, when we apply for jobs or elevation in the judiciary, should you as a judge also have a category where you say, my social media friends include so and so? What is the effect of such a declaration? Ethical issues will also arise. Suppose I share information on social media on a particular subject, and the same subject is coming to my court. Will I have been judged to have predetermined that subject? Will I have been seen to have had a bias? Suppose the president of the Law Society sends a post on Facebook, and all I do is I like that post. Will I have taken a position on that subject? If I share that post, or I comment on the post, or I put as my status update, will I have been seen to have been biased and taken a position on a matter that I may have to make a judgment on as a judge? We do not have guiding rules on what is acceptable and prudent to a judge. And I submit to you that a judge is expected that every post, every comment, every document shared on social media must maintain the dignity, the independence, and must always stand guided by the Judicial Code of Conduct and Ethics. The Kenyan Code of Conduct and Ethics 2020 speaks to social media and says a judge can have presence in social media, but you cannot make a presence that compromises your independence as a judge. The second issue I want to address is the courts and social media. The emerging trend from my reading is that now the courts are reaching out through public various social media platforms to communicate aspects of the court. The Constitutional Court of South Africa actively communicates on Twitter. The Kenya Judiciary has a Twitter handle, but not specific court handles. My Supreme Court does not have a Twitter handle. Some of the information that they disseminate includes the day and time of hearings, pre-hearing, post-hearing, judgment, media summaries, and the court's judgments. When we finished our case the other day on the BBI, we posted out to the media handle of the Judiciary the media summary of the BBI judgment, and later we posted the whole judgment on Twitter. Other courts, the Supreme Court of the United Kingdom, and I was there the other day, the United States of America Supreme Court also have a lot of presence on Twitter. In some courts, in fact, it's not handled by a judicial officer, it's handled by a judge who's the one who heads and approves all matters that are disseminated to the social media. Some courts in Kenya, for example, have on Facebook updates, and they pass the court list. They post the court list every day. They post notices saying that the courts are not sitting, the magistrate and judge is out. Right now, as we embraced digitalization in Kenya, and I'm spearheading digitalization in Kenya, and during COVID, the COVID period, e-filing became institutionalized. We have had to use social media to project our decisions and our policy issues. Former Chief Justice of Australia, the Supreme Court, Marilyn Warren, said this about the internet and social media and the courts. The internet and social media are here to stay. The courts must develop constructive strategies to engage with the new technologies. Open justice in this age means the ability of the community to view or access information about court proceedings through the internet or social media, as well as through traditional print electronic mediums. The point being that we must embrace technology as we know it in the judiciaries. And like I said at the beginning, traditional media is declining. And social media platforms then would offer an opportunity for the system, for the court system, to speak to the public, publicize information, which may not necessarily be accessible through the print and television media. It also would help in demystifying the role of the courts and humanizing the courts. Sometimes the courts are seen as being aloof. Judges are being seen as being aloof. Social media being the new future would give the courts an opportunity to demystify and humanize themselves. But I must pose a caution. Courts need to decide what would be the most effective social media tool to use, and the responsible officer in charge of the particular social media account. The courts should also consider the extent to which they should engage with the public on public forums. In a paper I read the other day called Social Media and the Courts, Innovative Tools or Dangerous Fad, a practical guide for court administrators by Norman Meyer Jr., at page 12, he lists 20 problems that social media can create with the courts. Misuse of social media leading to aborted trials are one of them. Misinterpretation of court work, difficulty in testing authenticity and credibility of social media journalism, lack of verification of social media publications, need to educate judges, court staff on the use of social media, improper recording of court proceedings, confidential matters, evidence, impact of social media on court orders, and all these questions that we all know can go wrong if we do not have a clear guideline on how to manage social media. Let me now address the elephant in the room. I have read what the Chief Justice of Tanzania said to young advocates the other day regarding social media. Some of you may have read what the Chief Justice of Kenya said in the BBI judgment regarding the use of social media. That is the elephant in the room. Social media, in my view, is a double-edged sword. On one hand, it helps in quick dissemination of information. It has also been used as a tool for expressing disappointment, disagreement in a judge's conduct, a judge's opinion. And as a result, judges' conduct has been publicly discredited on the impartiality question. There have been many instances where people have used social media to attack individual judges or the judiciary as a whole. And the effect that such attacks is likely to have far-reaching effects because social media posts are permanent and they reach a lot of people in a very short time span. And our courts have recognized the damage that results from social media. In the Kenyan case of Arthur Papa Odera versus Peter Ekesa, Justice Bogoli, now of the Supreme Court, awarded the plaintiff damages for Kenya shillings 5 million after the plaintiff sued the defendant for comments made on Facebook. That was the first time Kenya ever had a judgment based on a comment made on Facebook. And the judge said, the defendant embarked on a path of character assassination totally unprovoked and made sure that as many people as possible consumed those allegations. With regard to judicial officers, this has become the norm more than anything else. Decisions are being attacked. Disgruntled litigants are using social media to attack judges and to attack decisions, not to appeal them. The effect is that such attacks will erode the independence and integrity of the judiciary. And the question that we must ask ourselves is this: what should the judiciary do if the attacks are inappropriate? I know, I recognize, I accept that in today's age and time, there must be public scrutiny of the judiciary. The judiciary cannot escape from criticism where wrongs are committed by the judiciary or by judges. However, what happens if inaccurate or misleading information becomes a subject of debate regarding a judge, judges, the institution? Should the judiciary keep quiet and not correct those inaccuracies, those misrepresentations that are made in social media? If not corrected, I fear the independence and integrity of the judiciaries will be greatly eroded, and the entire administration of justice, including you, the advocates, will come into eternal disrepute. Sometimes we treat judges as if they are stones. The judges don't have feelings, judges don't have family, judges don't have emotions. But judges feel the pain of unfair public criticism. Are we supposed as judges, therefore, to remain calm and speak through our judgments, as has been said previously, that a judge would swallow insults from on social media, hook, line, and sinker, and never respond except through a judgment? Suppose there's no opportunity to write a judgment on a social media attack. The question that we must ask, therefore, is this: what should judges do? The meeting I'm attending right now, where I am, had a question around that issue. My suggestion to the judiciaries is that there ought to be an officer in charge of communication who should respond to these questions whenever the need arises, to clarify, to set the record straight, to explain inaccuracies. And this way, a judge is not dragged into the mud of social media, because social media can be nasty, brutish, and very muddy. The judiciary must also propagate its own narrative. It must have a way of explaining its policies, its decisions, its actions, and not only be reactionist and wait to respond to attacks which come from the most likely and unlikely sources. Above all, the judiciaries must guard its independence and integrity by conduct of ourselves as judges that will not attract such criticism as would erode the confidence of the judiciary or of the public in our judiciaries. I submit to you that social media presents an opportunity for us as lawyers on both sides of the aisle to engage with the masses, build confidence in the judiciary and in the bench, in the bar, Let people feel connected with the courts and the bar. Because it is not just judges who suffer attacks. Lawyers do suffer unfair attacks. The other day, an advocate in Nairobi received orders against a litigant who threatened him on social media, who threatened him on WhatsApp, and he finally got justice in the courts as an advocate against an adversary on the other side. We as judges also, while using social media, must exercise restraint and caution. And our behavior and conduct in the public and in social media must always reaffirm the people's faith in the integrity of the judiciary and in the eyes of the public, and we must be above reproach. Courts should also take advantage and maintain an online presence. And both the bar and the bench must come with strategies to overcome the dangers of social media, while at the same time tapping into full benefits and opportunities that are presented. For example, I had a conversation with a friend of mine, an advocate, and he submitted that the sub judice rule is dead in view of our very robust constitutions. And I said to him, so far as I know, this sub judice rule was stated for a purpose. The other day in the BBI judgment, we said to some lawyers, it is not right for you as an advocate sitting in a matter in court. As soon as you leave the court and before a judgment is rendered, you tweet about the merits of that decision in breach of the sub judice rule. Now, my question is to you, learned fellows, if the sub judice rule has been with us for hundreds of years, do we kill it because of social media? What was the purpose for which it was created? Has it become obsolete merely because we now have the freedom to speak where we want in social media? Where is free speech if you hide behind a pseudonym in social media to attack a judgment in which you appeared in your case instead of going on appeal? What about the mutual respect that I learned when I joined the bar on the 19th of January, 1991? The bar and the bench must respect each other. Where is that respect in the face of faceless social media presence? How far should advocates go in criticizing court decisions? Where does academic critiques, and I see my friend Professor Abuya right here, how far do academic critiques go? Where does criticism end and insult and defamation start? As lawyers, these are things we know. What is the role of the law societies in bringing errant lawyers to account for what they do on social media which crosses the line? If an advocate appears before me today and tomorrow morning goes to social media and attacks me in my personal capacity, not my judicial capacity, or attacks my judgment in a matter that he has a right of appeal, calls me a nincompoop, a fool, this and that, is that the way we're taught as professionals to engage with each other? If I were to write a judgment myself and attack the president of the law society and call him names, then cut out that particular portion and paste it on my Facebook page, where will the respectability of our profession be at? Is that how we're taught to account for our actions? Do law societies have a framework to address these questions? Does the Law Society of Kenya, the Senior Council Bar, the East Africa Law Society, Uganda Law Society, do you have frameworks? Do you have guidelines? Do you have policies to address these questions? And why not? Is it not time for us to have these questions? Is inappropriate use of social media not misconduct that can be taken forward through the systems of justice within our societies? Yet again, we must look back to ourselves as judiciaries and say, don't point fingers at the advocates alone, point fingers at yourselves. Chief Justice Mutunga, retired of the Kenyan judiciary, once said, that he was wary of monarchical judiciaries. Judiciaries where judges are held as if they're monarchs. How do you restrain the prevalence of such judiciaries without demeaning the authorities of the courts and calling those judges who are errant to account, not necessarily through social media, but through channels that are known to our legal systems, and there are many. My point is this: there must be respect between the bar and the bench. There must be mutual respect, even in the use of social media. Let me then address contempt. Should social media posts regarding a live matter attract contempt proceedings? That is easier said than done. All our laws, all our judiciaries have contempt laws. My question is, who should be called to account for in contempt? Who should be punished? The initiator or the publishers too? Suppose the initiator, the initial post, person who posts the item, use a pseudonym. How do you get that person? But suppose the original person uses a pseudonym, but David uses his own name to repost that post. Is he guilty of contempt? These are questions we must keep asking ourselves. I submit to you, therefore, as I close, advocates must self-regulate in the use of social media. Judges must self-regulate in the use of social media. Law societies must create guidelines to manage use of social media. Judiciaries must do the same, because social media is here to stay. Judicial independence is here to stay. Freedom of speech and expression are here to stay. But the limitations in the social media space can never, ever be forgotten. I have raised these questions because this is a new conversation. And I thank you, President, and your council for thinking fit that we must begin this conversation here today. Mutual respect between the bar and the bench, eroded as it is in many jurisdictions, must be reclaimed. And social media should not be the death of that respect. I thank you very much. I'm happy to take questions. Thank you, Mr. President. Thank you, everyone.
Thank you very much, Honorable Justice Lanaola, for that presentation. I think it gives a fitting introduction to this topic, and hopefully we can have more of these discussions as we go along. As the Honorable Justice has shown in his presentation, the role of a judge has been traditionally come with weighty obligations and burdens. Judicial officers do not have it easy. They are held to high standards, most of the time restricting the personal conduct of the judges' lives in and outside court. Because judges are representatives of the law in the eyes of the public. So independence of the judiciary is therefore a sine qua non to the rule of law. But what is judicial independence? Judicial independence entails several things. First, of course, the most obvious being the independence of mind and decision making, impartiality, integrity, equality, competence, of course, and diligence. Now, these are practical matters, but they are also matters of public perception. And therefore, public perception must be taken into account when we discuss independence of the judiciary. Social media has created a wider public, so to speak, a wider public, a public that is not limited by the traditional limits of geographical jurisdiction, pecuniary jurisdiction, and physical access. So therefore, a judge or the judiciary is at once exposed to a much wider public. And so this discussion is very essential. With the task that lies on the shoulders of judges and the vagaries of unlimited social media reach and use, it is for us now to discuss whether the judiciary as an institution should use social media, and to what extent and for what purposes. Whether the individual judges should use social media, to what extent, for what purposes. And perhaps which categories, there has been a debate, which categories of social media should the judges use? The social media has been characterized in two broad categories. Social media, which is really only meant for the social aspects of life, but there is also that one which has a more professional aspect to it. Very obvious examples are LinkedIn, is a more professional leaning social media, while, for example, Instagram or TikTok or the others are mainly more social based in the real sense of the word. Should the judges be limited in one way or the other? So those are the questions. But the other question is, a lot of discussion in the jurisdictions that have attempted to regulate the use of social media and the judiciary have mainly focused on regulating the judge and how the judge uses or ought not to use social media. But where does the advocate lie? Is the advocate, truly speaking, still an officer of court? Or have we completely forgotten this vital function? If we are officers of court, how should we conduct ourselves on social media vis-a-vis the independence of the judiciary? Is it not also incumbent on us to promote and to protect the independence of the judiciary? Should we be regulated in some respects on how we interact as lawyers and as advocates on social media vis-a-vis the independence of the judiciary? And which brings in the rules on contempt, on sub judice, and others. So, ladies and gentlemen, this session is supposed to be interactive. These are the questions that are posed for debate and for discussion. We will invite as many questions as we can, and we will welcome you to this discussion. So these questions, perhaps we can all contribute. We can ask the questions by way of chat, and David will help me if there is any hand up that we can deal with orally, but chat will be very important. Mr. Michael Mushi asks, is there any law that prohibits a judge for interacting on social media? That is one question.
So far as I know, and I know the experience of my code of conduct in Kenya, our code of conduct specifically says that you're not prohibited. I was trying to get it just now, but I'll try and get it later. You are not prohibited from engaging in social media, but the proviso is that it should not affect your independence, your integrity, and the administration of justice. So that's the right to engage in social media. So in Kenya, we don't have a problem there. And that's why a number of judges are quite prolific on Facebook. As I sat here, I've just seen a comment from a colleague judge of mine at the Court of Appeal on someone, and he posts almost every day. We don't have a qualification in Kenya, I mean a restraint in Kenya. Thank you, Enoch.
Okay, thank you, my Lord Justice. Now, perhaps one of the more fundamental questions, as I did say in my short remarks after your address, my Lord,
Yes.
that the judges have weight obligations. The judges have a burden. They are judges in court and outside court in every aspect of their lives. So we do not allow them to rest from being a judge. There is no time when they are not judges. That is why they are representatives of the law in the eyes of the public. How do we balance? And in light with this question, how do we balance the right of the judge to express themselves and the right of the judge to be a participant in society around them, to live in society normally, vis-a-vis this obligation that we have burdened the judge with?
Thank you.
So on the one hand, we want to restrict the judge, keep them a judge, but should we, and of course I urge that we should not, should we completely isolate the judge from society? And then how do we balance with the judge's right to live in society, to express themselves and to participate? I will be coming back.
Thank you. Fantastic question. And I think I should begin with the other question, which was this. When does an advocate stop being an officer of the court and becomes an officer of social media? My answer is very straightforward. A judge is a judge 24/7. My conduct on this webinar, my conduct in a restaurant, my conduct in my court should reflect the fact that I'm a judge. There is no doubt about that. Number two, an advocate, similarly, with regard to issues affecting the administration of justice, is an officer of the court 24/7. Social media and outside social media, court and outside court. I cannot understand anyone telling me that when I go out of the courtroom, I'm a different animal and therefore I behave differently as regards matters that I've handled in court. I don't think so. Neither can a judge be. I think for me, the answer lies in your first comment and my own submission. We need to regulate, apart from self-regulation, we need to regulate these matters with guidelines that are acceptable and agreeable across the board, on both sides. So I have no doubt that even as we socialize in public or in social media, we cannot change anything beyond what we're taught. Professor Buya, your question is this: are there examples? In my readings, apart from the US, Australia, and the UK, where they have gone beyond by creating guidelines and having documents and writing about this, we are very, in our jurisdictions, we are very limited. I think apart from the Kenyan Judicial Code of Conduct, which has a specific mention of social media, I have seen nothing in Uganda, Tanzania, Burundi, or Rwanda. Neither have I seen anything that I can speak to which address this question. However, in her judgment, Chief Justice Koome the other day mentioned guidelines which came out of some code of conduct, and she quoted a specific line there where she said that the responsibility of advocates in social media can lead to punishment for misconduct. So I'll send that document to the society for circulation. But outside those, Professor Buya, I know nothing else which speaks to social media in our jurisdictions. I thank you.
Thank you very much, my Lord Justice. Edwin asks a question. In the absence of any legislation barring judges from using social media, how can we regulate the use of social media? That is the one of the questions.
I think
there is maybe let me pause just
yes,
another quick one. Are
Yes.
there any comparable examples which you can share, or put differently? What is the position in other jurisdictions you mentioned, such as Australia, the UK, the US? And then are lawyers allowed to comment on the court decision on social media? At the moment, let's first start with those, my lord.
Okay, then let me begin from the Daisy's question. Submissions in the absence of any, how do you? I think myself the way to do it. Let the Law Society, East African Law Society, being a neutral law society in a sense, begin the conversation leading to regulations on use of social media. If East African Law Society can begin that conversation, put together a team of lawyers from across the region, who can then sit together and borrow from everywhere, our own experiences, put together regulations, they can then be shared across the region. Let advocates input in those regulations, and then we pass them in the usual manner as law societies. I think that's a good way of carrying everybody on board, because our views on this subject are diverse. So I would think myself it's best to have everybody putting their thoughts together for us to have any serious question. I answered Edin's question, Professor Buya's question. Are lawyers allowed to comment on court decision on social media? My view is this. No one has stopped a lawyer from commenting on a court decision on social media. But I asked the question, why are we taking the view that the sub judice rule is dead? The sub judice rule is well and alive. When a matter is pending before court, when a matter is pending a decision, we should not comment on social media. Once a matter is rendered and there is a decision, and you're not a party, you're not an advocate in the matter, you can comment on the decision. But what is the nature of the comment? I asked the question, is it a critique? Is it criticism? Is it an insult? Is it defamation? The answer lies in your knowledge of the law. If you comment on this question, on a decision, and say, I disagree with the judges on this question, who will stop you from disagreeing? But what is the language you use in expressing your disagreement? That's all I'm saying. I mean, the right to speak and comment on decisions is never restricted. I think I've answered the ones that you've asked me to. Let me speak to my lawyer's question. Steve, you asked the question, in the US, there's a code of conduct for misleading the court or putting false pleadings. Why are courts hesitant, reluctant to express similar? I think our courts have been reluctant because we do not have any specific precedents on punishing errant lawyers. I recall one time when I was a High Court judge in Machakos, I actually punished an advocate personally in costs for misleading the court through pleadings. I think where we need to go, and I have no doubt we're going to go there soon. If an advocate disparages judges on social media platforms, there are sufficient precedents in India, in California, for barring those lawyers from appearing in particular courts until they apologize. The orders must be given for them to pull down those social media posts. That time is coming, because if we do not restrain ourselves in the manner we're taught in law school, both as judges and advocates, there'll be punishment coming sooner than later. So Steve, I have no doubt it's coming, because that's the only way we can save ourselves from the ignominy of misuse of social media. Judges from, we are not getting, we are saving judges, you said, I think the pious. I said myself that we must restrain, and Enoch has added to that by saying, we must determine where a judge should appear in social media. And you're right. If you decide as a judge to dance in a pond with pigs and your robes are stained with dirty water, then you cannot complain because you've taken yourself there. But we must address that matter across the board. Advocates should also not become pigs. Advocates wear robes like judges. They should not stain those robes by the dirt of social media. So perhaps I agree, but it cuts across both ways. Thank you, Enoch.
Thank you again, my Lord Justice. Speaking about ponds and pigs, would an advocate, and this is a perhaps even a rhetorical question, but for us, the advocates, would this pond be any different if it were a physical one and we are sitting in a hall? Would you be able to say what you are saying on a floor in the presence of judges that you are posting on whichever social media channel there is? In other words, does this anonymity of social media, does its instant communication abilities divest us of accountability in terms of how we communicate? I submit it doesn't. And I submit that we should not make social media any different from our ordinary day-to-day communications. It has simply just become a channel to amalgamate or to collate our addresses to the public. But should it be any different? So I disagree that a judge would be playing in a pond. It is no more a pond than it would be if we are all sitting in a hall physically and having a discussion.
I think Enoch, let me answer that,
yes,
because that's an important point. My point was this. I think Pius was saying, if a judge takes himself to social media, engages in debate with an advocate on social media, then you have taken yourself to the pond. But your other point, which is more fundamental, is this. If an advocate cannot say things in open court, where is that courage that they get to go and say things in social media? What kind of advocate would have courage to speak in social media anonymously, but cannot say the same things in open court? And that's why you and I agree, Enoch, that because you are an officer of the court 24/7 and a judge an officer of the court 24/7, our conduct everywhere must be the same. It must be consistent. But I think I understood Pius to say, if a judge engages in debate on a subject in social media with an advocate, then he has taken himself to the pond. And I'm saying, why are we going to the pond in any event? So yes, we agree to that extent. Thank you, Enoch.
and for Pius, you might want to perhaps give us an insight regarding this analogy of the pond and getting into the pond. Why would you begin a discussion which is intended to malign a judge who does not have a right or who does not have the ability to defend themselves? But Stella has had her hand up. Can somebody please let Stella ask her question? I don't know if you can hear her. David, can you manage that?
She can proceed. She can unmute and proceed to speak.
Thank you so much for the nice presentation, Johanna. It's really amazing and very giving open our eyes more as a professional. For me, I have one opinion as a normal citizen, I can say like that, because I think we as a professional, we have to adhere with the principle of rule of law, integrity, and we have also the right to opinion. But I think, to my opinion, before we do anything, not only on the social media, even to when we are alone, like, integrity, I think we have to adhere with the principle of integrity more than anything, because there are some people also, they don't do anything on social media, but they behave maybe somewhere else, not really as a good image in public, like in bars. There's a lot of things I think we have to address very well, because I think the essence of us being a court, like office of the court, is to have good manners, not because we have to argue or do anything, no, but I think we should adhere with the principles, but also we should not forget about the principle of integrity, because sometimes I think we are more concerned about A, B, C, D, but there's a lot of stuff ahead of us or behind of us we have to deal with before stepping more in other issues. For me, I don't say I'm against people maybe who they raise opinion, but is that building, if someone read your comment, is it really motivated or can learn something from you? It's very important, because whatever we speak, it has an impact, whether it is good or bad. For me, to my opinion, better we are there with the principle of integrity, not only because we are professional, as a normal citizen, because there are a lot of tough people they can learn from us apart from being a professionals. Thank you so much.
Thank you, Stella. I think Enoch, she has touched on something which I said in passing. Self-regulation, self-respect, personal integrity, restraint, good manners, etiquette, respect. These things are not taught on social media, but we're taught as children in school. We don't have to be professionals to know these things. They're such things as just good manners. So I think, Stella, you've touched on something quite simple but straightforward. I thank you.
Thank you, Stella, indeed, for those comments. And just so that we are on board, as I did mention, there's been considerable effort in regulating the judges' side of things, and in various jurisdictions, several things have come up, but perhaps the more common ones are there is the Doha Declaration by the Global Judicial Integrity Network, which talks about guidelines on the use of social media by judges and judicial ethics training. And that same Doha Declaration gave birth to non-binding guidelines on the use of social media by judges. You might want, ladies and gentlemen, to research these ones. And I see somebody has posted it. I think Nikhil Fiswang has posted a link. You might want to look at that. The question is, should there be a similar sort of regulation? And I think this is what Justice Lanaola asked, where are our law societies? Should there be a similar framework of regulation for the lawyers as there is indeed for the judges? Should we, even for the judges, streamline this sort of regulation, even for the judges in our local jurisdictions? Because as we have mentioned, different jurisdictions are dealing with it different ways. Those are the questions and comments. David, could you help me with any other question?
There is somebody called Juma Eras. He's raising the hand, please. Juma Eras, can you proceed? Can you unmute and proceed?
Well, thank you very much. My name is Juma Emmanuel Eras, and I'm tuning in from Arusha, Tanzania. I very much agree with my Lord Justice Lanaola with the aspect to critically establish limitations and bind lawyers and judges in their approach and use of social media. But I decide to deviate a bit and actually add up that one amongst the intricacies of a good law, it is quite interesting, and from my end, I am a bit disappointed with the fact that we do not have specific provisions in our laws and other regulations that guide the conduct of lawyers to limit their use of social media. Now that's to exclude the to exclude the Republic of Kenya. So I therefore add up that there should be initiatives to further adapt specific provisions which will now at least extend the information and reality to the extent to which lawyers could further be informed, and then limit the extent to which we're engaged in social media. Also, not so much to pour blames on lawyers, knowing that they are human beings. Sometimes feelings could further extend, to pull a person and make him or her commit or do something that is unethical, because maybe he or she is influenced with the decisions and so forth. So to avoid and to limit the same, I think it is now a high time that there should be specific provisions in our laws to govern the same. Thank you very much. I submit.
Thank you, Juma.
Thank you, Juma. And perhaps coming from Juma's submission, that is the question. We have rules of ethics. We have a code of conduct for lawyers, for advocates, for judges. Why should we separate the application of that code of ethics or code of conduct from application on social media? And that is a question for us to answer. I'm trying to follow some questions here. The question from Nicholas Mugara, I think.
Yes. Mugarura.
Yes, Mugarura. Can Justice Lanaola possibly draw a line between counsel's right to a political opinion on social media versus a legal one in view of what was said about counsel when the BBI judgment was being delivered? This is without prejudice to your sitting on that bench. Thank you for that presentation. That is the question, my Lord Judge.
Nicholas, I think the line is clear. Political opinion, any lawyer can express political opinion on social media. It's a right under the Constitution, Article 32. No one should ever. The issue in the BBI judgment, according to the Chief Justice of Kenya, was this: counsel sits and submits for hours on a matter before the court. The court retreats to go and write a judgment. In between, counsel appearing in the matter starts commenting on the merits or demerits of the decision, and even predicts how the judges will rule. I mean, that cannot be allowed because the sub judice rule exists. So the answer is simple. The BBI judgment obiter by the Chief Justice was to say, once you made your submissions in court, retire. Go and comment on political matters if you must, but let the court make a decision, because when you start commenting on social media, the impression being created out there is that you are either intimidating the court or you are actually prejudging what the judges will say. That was a simple question. And we don't need to be told that in the judgment. We know this because of our training as lawyers. So thank you, Nicholas. Fantastic point. But have your opinion, express it as you wish, but let's limit our concerns about pending judgments and matters pending in court. Thank you, Enoch.
Thank you, my lord. Faith Macharia. Sorry, they still trying to, let me get this one. Faith Macharia says, we cannot discourage members of the judiciary from taking part in online communities. Socialization through social media does not merely guarantee judges freedom of expression, but ensures it ensures active participation in social life. Now, when you propose that an office to be created by the judiciary to handle and clarify issues on social media, would this be done in consultation with the judge in question? And to what extent can this be done on behalf, and can the judge be allowed to do it directly if they so wish? Can it possibly reopen the issue, taking another life in social media? Again, I think the question here also is in this separation between when we talk about the judiciary as an institution and the judge as an individual judge. Where are the limits?
Thank you. Thank you, Faith. I have nothing useful to add to your submission. My last point is, your last point on the relation of social media, I think is important. And our code of conduct actually uses the words, a judge is a member of society, blah, 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 and then social media. I'm trying to get it downloaded, but the code of conduct is not downloading, so I'll send it later. But yes, Faith, thank you, and I agree with you completely. David Njoroge, the proposal we are making is this. Social media has become so big. Right now in the judiciary, what we have is members of the communications directorate. What they do is we receive every morning a summary of all stories in the print media relating to the judiciary. This is our way of getting feedback and for us to respond where necessary. For example, if you recall, David, there was a time that an 80-year-old was jailed in Embu, and there was a big kerfuffle around the question. Just last week, the former prime minister raised a question of this guy who was given some sentence. What we try to do is to, every day, we bring together that information so that leadership in the judiciary, the chief justice, principal judges, resident judges, can get to know that there is an issue out in the public, and in reacting to the public, we must be able to respond either by saying that matter goes on appeal, or that matter goes for review, or that matter goes, it's not a matter, it's a matter for the ODPP. What we're talking about social media is the same thing. We try to monitor social media so that if there's an issue that requires attention, requires an address by the judiciary. For example, if on social media somebody says, my case has been in court for 10 years, it's been adjourned 100 times. That's a matter you can very quickly pick out of social media, call for the file, call the advocate or the person, look at the file, see the delay, and address it in the system, that in the usual manner. So we are saying, let's use social media in a proactive manner. But if, for example, there is an insult about Judge Lanaola, as happened yesterday summer, what will happen is that person will pick out that post, seek a commentary from me, and then the judiciary as an institution can respond and say, there is a comment we received about Judge Lanaola in this matter. The comment by Judge Lanaola is as follows, and the comment, and then it goes out. So it's a manner of being accountable to the public. And so, David, we are trying to say, let us be accountable without opening a Pandora's box. And I agree with you. Let the matters rest once there's a response. Don't open another argument, because social media can be very, very harsh. You can open a Pandora's box. Yes, social media can be very short-lived. Once the story has died, a new one starts tomorrow on Twitter. Twitter stories don't go more than 48 hours at the very most. That's my point. Thank you.
Thank you very much, Honorable Justice Lanaola. Mr. Thomas Mwangi asks a question. Would it be improper use of social media for a judge or magistrate to personally invite media to the courts when delivering judgments of public importance?
Thank you very much.
And just another quick one, my lord. Saroma Sadiq, we have guidelines as judges and advocates. How about the society behaves against good manners and attacks? What happens when the society behaves against good manners and attacks you personally? If that happens, what should be done?
Thank you very much. Tom Mwangi, there is nothing wrong. Previously, we never had a robust communication department in the Kenya Judiciary, at least. And when I was at the Human Rights Division at the High Court, what court reporters would do is once I've announced through the cause list that there's a matter that I'm giving a judgment in, they would then ask me or my deputy registrar or my clerk whether they can bring their cameras to court, whether they can bring their, so there's nothing wrong. What we do now is, say in public interest cases like the BBI and others, the communications department would then communicate to journalists and say, there is this judgment, would you like us to arrange for you to have media presence? And if you notice during the BBI case, the election petition cases, what happens is that we have a media tent where the media can follow proceedings and take their recording, and then they have cameras in court. So we have opened up. It's no longer restricted, except of course, in matters in camera. A few years back, I handled a case that came out of the ICC, and because of the nature of the matter, I had to do the matter in camera. And when a journalist tried to come into the court, we had to close them out because the matter was sensitive and required the matters in camera. But generally, our proceedings are open to the public, and in fact, no invitation is needed for journalists to attend. Salma, you are separating between attacks, quote, attacks by advocates and attacks by members of the public. My understanding is that it is different if a professional who ought to know writes a disparaging comment on social media. If a member of the public writes a disparaging comment, then, like I said earlier, in the case of, in the judgment that I gave by Justice Mbogoli, the case of Papa versus, how can I forget it? Yeah. In that judgment, the judge said, Papa Odera versus Peter Ekisa, if I feel defamed by a member of the public as a judge, I have my rights. Like Faith Karanja said, judges are members of society. I have personally sued previously for defamation through a paper. So if I feel offended and I feel defamed, I have my rights as an individual to sue for defamation. But as much as possible, judges should avoid filing cases before their own courts of whatever nature, including defamation. Thank you very much, Eno.
Thank you very much, my Lord Judge. Could you also say that, in fact, in regard to that particular question, that the rules on contempt also apply actually to the public in as much as they would apply to counsel?
That's correct. That's correct. If a litigant, for example, there's contempt within the court, there's contempt outside the court. Social media is outside the court. So if someone, for example, a litigant, makes comments that are actionable in contempt, obviously the court can do what it has to do, and there are procedures. In the Supreme Court Acts, for example, we have procedures for addressing contempt in the face of the court and contempt outside the court. Yes, you're right. It's actionable.
Okay, thank you, my Lord Justice. Mr. Elia Mgoya asks, in respect of the subject, how will professionals such as judges, advocates, and the others be held liable in the misuse of social media due to the fact that we lack the laws that govern social media? And how can the rules and guidelines that govern on matters of integrity, conduct, and so on and so forth be applicable on this subject?
Thank you very much. And I've seen that the Papa Odera case has been posted by someone. Thank you. The question has disappeared from the screen, but I remember it. If you remember, I said earlier, I think for me, the best way to do this is to regulate by regulations, both for judges and for advocates in the use of social media. And this regulation should have a conversational tone so that each one of us is carried along, public participation. Let all advocates, let judges input into these questions. So for me, that's the answer. The fact that we don't have does not, however, mean that it's a free-for-all, and we can ignore all the basic tenets of our professionalism and do what is really untidy. So that's the way to go. Let's go forward, but in the meantime, let's behave ourselves.
Thank you very much, my Lord. Yes, David, were you saying something?
Yes,
Achilles.
Messi Chepto, she had risen and for quite some time.
Can she come in? Yes, please.
Messi, if you can hear us, please can you unmute and proceed to ask the question?
Master Chipto. She's muted.
Mercy, if you're trying to speak, kindly unmute.
I hope we didn't delay her too long and lose her.
She's there,
You
but
can
she's
proceed.
muted.
Okay. Mercy, you can unmute and come in when you're ready. But in the meantime, there was a previous question that was asked, and essentially suggesting that there are no rules. I would like to submit that we have the rules. We have a code of conduct that we go by. We have ethical guidelines that we go by as advocates. The danger, though, is that we have separated social media from normal lifestyle. I think what we would need to do is simply to tailor, to add the detail, to simply add the detail. But otherwise, the same code of conduct governs us as it does in our ordinary day-to-day lives. I would not go outside court, for example, in the road and shout while I'm outside court and start shouting, oh, these people who are in this building, these judges, X, Y, and Z. I would just be as wrong doing it outside court.
Yeah.
If I did the same thing on Twitter or on Facebook or wherever. So I think we need to accept, first of all, perhaps to reappraise ourselves of what our ethical standards, what our code of conduct, are we following these, or have we simply forgotten them and we are living just as such? Marse, are you there? David, are there any other questions on your side?
No, actually, all the questions has been responded to.
Yes.
Enoch, I have
Unless-
a very interesting comment from a judge colleague of mine in Kenya.
Yes, please.
The judge has sent a quote from Mike Tyson saying that social media has made you all way too comfortable with respecting people and not getting punched in the face for it. Because social media, you go like what Enoch is saying, you are comfortable going to insult judges or even colleagues of yours outside their faces because there's a risk of getting punched in the face for it. That's a joke, but I think it makes the point. Thank you.
Yes, quite makes the point. Of course, social media, one of the biggest things that social media has given is anonymity. And in fact, there is a debate whether a judge using social media should use their proper identity as an individual, whether if they use that proper identity as an individual, they should mention that in fact they are a judge, or whether they should use a pseudonym to participate on social media, or whether they should restrict themselves from certain applications on social media, for example, LinkedIn, and refrain from others. And all these from jurisdiction to jurisdiction are being debated. But the main point here being that the judges are definitely disadvantaged when it comes to dealing on social media, because it would appear that the judges have maintained the alertness of the ethical codes that govern them, while on the lawyer's side, we have tended to lose our alertness regarding those ethical codes in dealing with matters in publicly. In fact, I would suggest that we appear to forget that we are officers of court, and therefore we are as much responsible for the independence of the judiciary as the judges themselves are. Yes.
I agree, because you see, why would an advocate be happy to give all their particulars in LinkedIn because a professional forum, and then give themselves some ridiculous name on Facebook because it's less restricted? I mean, just decency, honesty would demand that, like you can see on the screen, I have put my name as Honorable Justice Isaac Lanaola. Why would I on Facebook call myself the cat rustler? Why are you hiding your identity unless you have to mischief? Professionalism demands that you are honest, courteous, and decent in what you do. So I agree with you, not completely.
Yes, and indeed, as you also did comment, my lord, that social media keeps a record of what you say. Social media also is not deceived about pseudonyms. It does, in fact, it can in fact recover the actual identity of the person, and you never know
Absolutely.
when that would be.
The other
So,
thing, sorry, Enoch, let me just make one last comment. I would like to address the young lawyers of this forum. You have a future, mostly a bright future. Social media never forgets. Whatever you post today in anger at a judge will be found when you apply to be a judge yourself. When I applied to be a judge of the Sierra Leone court, I was interviewed by a panel in New York, virtually. They went to the internet to seek every information about me, including all the posts I'd made on Facebook and all the writings I'd made, which were on the internet. Please, for your own sake, post only what you can defend 10 years from now, because that's where your future lies. I thank you, Enoch.
thank you very much, my lord. I think it is useful to remember this is something we often forget, is that with every right, there is a corresponding obligation. So while we are always well within our rights to express ourselves, we must always remember that this right of expression is not unlimited. It comes with corresponding obligations. And these obligations are what bring us to account. I thank you very much, my lord. If there are no other questions, I will ask perhaps the President of the East Africa Law Society, Mr. Bernard Owundo, to move a vote of thanks, most especially to the Honorable Justice Isaac Lanaola, whom those of us who joined at the very beginning know that even right now he's on some duty, and he has taken his time out to come and be with us on this forum. Mr. President, please come in.
Thank you so much, Enoch, for an excellent moderation. I think that we made the right choice, and I'm happy with the conversation that we are having. My lord, the questions that you have raised are essential, especially the questions regarding the role of the law societies, and your appeal to us as the East Africa Law Society to constitute a committee on social media is very welcome. On behalf of the Governing Council, we will do our best to have this committee constituted so that we have a position paper on how we relate to media as lawyers. So we will take the challenge up, and thank you for your wise counsel, my lord. My lord, on behalf of the Governing Council, and indeed on my own behalf, I would like to take this opportunity to thank you again for taking time off your busy schedule to share your thoughts on social media and the independence of the judiciary. My lord, it has been a worthwhile evening. While you were speaking, I was writing and I couldn't stop writing. The issues you raised are very critical, and we shall continue to have a conversation, not just with the judiciary, but also with our members of the East Africa Law Society. In fact, we hope that the next session will feature an advocate who believes that there should be no limit, so that we can also be able to hear them out on why they think that no limit. So that is the way we were trained, and we will continue to have that sort of useful conversation. My Lord, also allow me thank the ELS Secretariat that has organized this webinar, and also allow me thank, very importantly, our attendees. They come from Uganda, Kenya, Tanzania, Rwanda, and Burundi, including South Sudan. We are very thankful to you, the attendees, for this webinar. Please look out for the other sessions, and I wish you a good weekend. My Lord, have a wonderful weekend. Asante sana.
Asante. Thank you very much, and thank you, everyone. I enjoyed this very, very much.
Thank you very much, the team from Secretariat. Thank you, my Lord. Just it's been great interacting with you. I hope that this is only a starter on this conversation. I thank you very much.
Thank you very much. Bye-bye.
Bye-bye. Bye-bye. Thank you. Bye-bye.